You know, I absolutely love stories like this one. It starts out with something so simple, right? A little disagreement about a homeowners association election, just a tiny question, and before you know it, it spirals into a full-blown official legal dispute.
Okay, so let's get right into it. Here's the mystery we're going to solve today. For the 2017 board election, was there one open seat or were there two? It sounds almost ridiculously straightforward, doesn't it? But trust me, the answer got so tangled up that a judge had to step in to sort it all out. We're going to unpack exactly how that happened.
And I want to be clear, this was not just some heated conversation over a backyard fence. No way. This right here, this is the official hearing document. This is what turned a neighborhood tiff into a formal legal case. We're talking witnesses, evidence, the whole shebang.
So, like any good story, we have our main characters. On one side, you have a homeowner, Tom Pyron, and he was absolutely convinced that his condo association had messed up, that they had violated their own rules for the 2017 board election. And on the other side, well, you have the association, standing their ground, insisting they did everything by the book.
So here's the heart of the conflict, officially filed on March 16, 2017. The association put out the call for candidates, saying there was just one open spot for a one-year term. But Mr. Pyron saw that and said, "Hold on a minute, that's wrong." He believed there should have been a second position open, a two-year term. And that one disagreement is the entire reason we're here today.
To figure out who's right and who's wrong, we have to go to the source of truth in this whole mess, the community's rulebook, its bylaws. Think of it like a country's constitution. It's the document that lays out exactly how things are supposed to be run. And in this case, the tiny little details in that rulebook, well, they change everything.
So how is this board even supposed to be structured? It's a three-person board, but the terms are staggered, 1, 2, and 3 years. And this is a pretty common setup, you know? It's designed to create continuity, so you don't have the entire board getting wiped out and replaced all at once. The key here is that each of these term lengths follows its own, very specific election cycle.
Okay, now here's a really crucial rule. I want you to file this one away because it becomes a huge clue later on. If a board member quits before their term is up, the rest of the board gets to appoint a replacement. But, and this is the important part, that new person doesn't get a fresh term. They only serve out the remainder of the person's term they replaced. Remember that phrase, unexpired portion. It's critical.
So we have the rules, but how on earth did things get so confusing? Well, the problem wasn't just one single event. It was this messy chain of elections, appointments, and resignations that basically tangled up the timeline and led to two completely different ways of seeing the facts. So let's follow the breadcrumbs.
Okay, let's trace this path to chaos. Everything's chugging along just fine back in 2012. But the real trouble starts in 2015. That's our critical year. You got two new members elected. Okay, sounds normal. But then one of them resigns almost immediately. The person who replaces her then gets elected to a new term in 2016. It's that sequence, the 2015 election, the quick resignation, and the 2016 election, that created this entire mess.
And all of that brings us to the hearing itself, where you have these two totally opposite stories about what this jumbled timeline actually means. Let's break down exactly what each side argued to the judge.
And this is where their stories just completely split apart. The homeowner, Mr. Pyron, is making his case. Look, Ms. Alstrand was elected to a 2-year term back in 2015. That means her replacement serves until 2017, so there should be 2 seats open. But the association, they're saying, no, impossible. The bylaws rotation system meant she could only have won a 1-year term. And if that's true, her replacement's term was up in 2016, leaving just 1 seat in 2017. The whole case, literally everything hangs on the length of that one board member's term from 2015.
So if you're the judge, how do you even begin to untangle this? Well, the judge basically had to become a detective, cutting through all the confusion, all the assumptions, all the "I thought this" and "we believed that," and focus on the one thing that doesn't lie, the black and white text of the bylaws.
The judge immediately zeroed in on the source of the problem, that chaotic 2015 election. All the arguments about 2016 and 2017 didn't matter if you didn't first understand what actually happened in 2015. By solving that one piece of the puzzle, everything else would just fall into place. And right away, here's the first major breakthrough. The judge looks at the bylaws, does the math on the rotation, and determines that in 2015, only 2 positions were even scheduled for an election, the 1-year term and the 3-year term. A 2-year term, it wasn't even an option that year. It wasn't on the table.
Okay, next up, the judge found something that was not in dispute, a fact that both sides actually agreed on. The bylaws are clear. In an election with different term lengths, the person who gets the most votes gets the longest term. And in 2015, everyone acknowledged that was Miss Singer. So she got the 3-year term. No argument there.
And this leads us to the final, beautiful, logical question. It's like a riddle, right? If the only terms available in 2015 were for 1 year and 3 years, and the 3-year term was just taken by the top vote-getter, what was the only possible term left for the other winner, Ms. Alstrand?
And there it is, the 1-year term. That's it. It didn't matter what anyone thought, she won. It didn't matter what was announced. According to the cold, hard logic of the bylaws, the only term she could have possibly won in that election was the 1-year term. And that one little fact just unraveled the homeowner's entire case.
And from that one deduction, the dominoes just start to fall perfectly. Because Alstrand's term was only for 1 year, it expired in 2016. That means her replacement correctly finished her term that same year. And that means the 2016 election was actually valid, which brings us to the final conclusion. The association was right all along. There was only 1 seat open in 2017. The homeowner's petition denied.
And here is the final word, the official, signed order dated July 12, 2017. This made the judge's decision binding on everyone. The case of the contested board seat was officially over.
So what's the big takeaway from this whole condo conundrum? At the end of the day, it's that people's beliefs, their assumptions, even what they were told, none of it mattered when held up against what was written in black and white. The bylaws were the ultimate authority. And it really leaves you with a question, doesn't it? Whether it's your HOA, your job, or even just a club you're in, how well do you really know the rules that govern your own community? Because as we just saw, the fine print really matters.